Okay, so thank you so much, Professor O'Donoghue, Professor Lochry, for that extremely generous introduction. It makes me feel humble, but also quite old when I hear an introduction like that. But thank you also to the MacDermott family for supporting this lecture and for showing up in such numbers, and also to all of you for coming. I'm very honoured to be here to be invited to give this lecture in memory of Lord MacDermott. And in writing the lecture, I've taken inspiration from the inaugural lecture he himself gave in 1972, which Joan already mentioned. But I just wanted to re-articulate that in that lecture, he exhorted us from time to time to scrutinise the health and condition of our principal legal concepts and to mark any trend or sign which might injure or imperil the common good, as I'm interpreting it. But I'd like to take up Lord MacDermott's advice to talk about what I consider to be a contemporary threat to the common good, and that is the growing imbalance between the relative power of large corporations and that of democratic states and the ordinary people in them. And I'd like to scrutinise some of the legal concepts that we use and offer students to shape and analyse that relationship. And I'm going to speak for about 50 minutes. I'm sorry, so don't start shaking yourselves at 40 minutes, just so that you're forewarned. But I think even before Elon Musk was given an office in the White House, I'm sure that most people here had noticed that large corporations and corporate leaders have been exercising increasing global influence in the world that we live in. Through organisations like the World Economic Forum that meets in Davos, corporations are expressing a will to govern, but at the same time they're paying little or no tax. They're setting up their own adjudicatory fora to rival national courts. They're suing countries for passing laws which address climate change or protect public health, and they're avoiding responsibility for the harms that they cause. In the public perception, I would say at the heart of the power of global companies is their ability to do business globally, but to escape national regulation, to be what Andrew Sanger has described as everywhere and nowhere. But although it does seem like the corporation hovers above the nation state rather than existing within it, corporations do need the sanction of national law to have legal personality, essential for the purposes of contracting and owning property, including owning their own subsidiaries. So a company always has to be incorporated somewhere. But once it is incorporated, it then has the ability to what I would shorthand as travelling, or to carry its legal personality across borders. Its ability to avoid responsibility and taxation then hinges precisely on this ability to travel, to incorporate in one place and to operate in another. For so many reasons, it's clear why companies want this ability. But given that it creates so much harm, why do we allow it? This question is the impelling concern of my lecture today. The answer to my question is that we allow the corporation to travel because we take the idea of corporate mobility for granted. No, it's intentional. It's when I want you to concentrate on what I'm saying with no picture. This is not, I didn't seem perturbed. I can see the reflection. So it's because we take the idea of corporate mobility for granted. We think it's normal, even natural, that companies can travel, and we seldom ask the question about whether corporations should be able to do so or what conditions might be able to be attached to that privilege. This is not because it is a self-evident good. It is because of what we have forgotten. The ability of corporations to travel was forged in the search for overseas expansion for profit. It is a legacy of empire. It has been patterned historically in a certain way into legal techniques, And that pattern has been naturalized in large part through the ways that we transmit legal knowledge. This normalization happens through the classifications of public and private and national and international, and the way we distribute certain doctrines, arguments, and questions to those categories. This distribution has been globalized through the emergence of the subdiscipline of private international law and is stabilized in its ongoing practice. So this pattern is true for many aspects of the company-state relation, actually, and in my wider research, the project to which Aoife alluded, I'm describing it as part of the repertoire of legal techniques devised to colonise others which have come home to bite. As the historian Richard Drayton has reminded us, empire always comes home in the corruption of democracy. So I hope that this argument is provocative in the sense that Lord MacDermott was hoping for, I think, to provoke us to scrutinise familiar legal ideas, to make them strange, and to mark any sign that might injure the common good. The hope is that this will allow us to consider afresh ideas which have become too familiar to see clearly. Only then can we ask meaningful policy questions which don't just tinker around the edges of corporate power. Okay, so with my teacher hat on, I'm going to tell you that in order to make my argument, my lecture will have 3 parts. In the first part, I'm going to sketch the history of how corporations came to be able to travel. In the second, I'm going to suggest how the idea came to be naturalized by offering a sketch of the salient aspects of legal education, both in terms of national and international law. And finally, I'll conclude with a gesture to why denaturalizing the idea might matter. I'm not going to have too much time at the end to talk about what policy space might be opened up, but we can do that in the Q&A if we want to. Okay, so let's begin by drawing a sketch, a brief historical sketch of the contestations over the ability of the corporation to travel and the legal techniques developed to enable them to do so. The story is different in different moments and places, but what's important is the idea that states can exist outside their state of incorporation was not always so obvious. In fact, it was a highly contested idea until quite recently. So during the 19th and early 20th century, great efforts were made by European and American actors to ensure that corporations could travel and do business wherever they went. Mostly they tried to carry their law with them, and these efforts went hand in glove with jurisdictional practices around securing contracts, gaining concessions, extending finance, and making treaties. There are 4 moments when I think this is particularly evident. These moments are the situation between states that ultimately federated into the United States is the first situation. The second is the situation between European empires. And the last 2 are the situation outside Europe, first inside the empires themselves, and secondly, in relations between European entities and peoples and places in the non-Western world which were not formally colonised. Let's take each of those in turn. Do you mind opening that for me, Aoife? Let's take each of those in turn. Okay, so at the turn of the 19th century in the United States, there was a lot of debate about whether corporations incorporated in one state should be able to do business in another state, within the Union. This was the time that you would probably know Mark Twain satirically referred to as the Gilded Age, which was a satire on the idea of a golden age because there was so much social upheaval and unrest covered in a very thin veneer of economic growth. At this time, the great American combines were forming in oil and steel, Rockefeller, Frick, Mellon, Carnegie, Morgan, Guggenheim. And over the preceding decades, a lot of efforts had been made by powerful actors to standardise corporate laws between jurisdictions in the United States. But the question of whether corporations could do business outside their state of incorporation was not resolved. Before the US Civil War, which ended in 1865, the leading case was the 1839 case, the Bank of Augusta and Earl. I'm not going to recount the facts and give you a short test afterwards, but the case involved a company incorporated in one place entering into a contract in another place. In delivering the opinion of the court, Chief Justice Tanay agreed that a corporation could have no legal existence outside the boundaries of the sovereignty by which it was created and could not migrate to another sovereignty. However, he held that the comity existing between states permitted one state to recognize the corporations of another state and to enforce its contracts in the courts of other states. The idea, oh, that's annoying, the little screen is covering my words. It says comity. The idea of comity was an old principle of encounter and an element of the law of nations which recognized the practical need for the mutual recognition of the laws and customs of another people's and grounded it in the courtesy of one ruler to another. There's a lot we can say about this, but there are two things I want to note here for the purposes of this very brief sketch. The first is that there was an explicit contest around the idea of the travelling corporation and its relationship to local authority. And the second is that the battle taking place amongst the states of the Union in the idiom of the law of nations was never resolved in that language. So it was never resolved as a question of should one state recognise the corporations of another state. Instead, it was sidestepped in the early 20th century by the assertion of US federal jurisdiction over the question. At around the same time, the question of the recognition of foreign corporate persons was also a live one between European states. When considering the status of their trading companies abroad, British jurists recognised that a corporation could have no legal existence outside the territories of the sovereignty which created it, because it is an artificial person which exists only in contemplation of law and by force of law. Where that law ceases to operate, the corporation can have no existence. The key to solving this problem was recognition. Other states must recognise the existence of the corporation abroad in order for it to contract and do business. As we've already seen in the 19th century, such recognition was grounded in comity, which was a matter of grace and not right, and which has its origin in the welfare of the state which accords it. Such welfare is the measure of recognition. In other words, this was a discretionary sovereign act, justified by whether the activities of the company would be beneficial to the state according the privilege of recognition. To stabilise relationships of mutual recognition, European states entered into a series of treaties or conventions which embodied the principle of comity. Here's an example from 1862 between the Queen of England and the Emperor of the French. I'm not going to read out the whole thing, but what I want to notice for the purposes of the next part of the argument is that these conventions crucially also extended recognition throughout the dominions and possessions of the other power. So by these treaties, European states were agreeing, as between themselves, that companies pursuant to their respective laws could exercise what they were claiming to be rights and have standing, in effect, some form of legal personality in the colonised world. Needless to say, the colonised peoples had no say in this. Outside the West, at least two different approaches were taken by Western states and empires to what they referred to as promoting economic relations, but we might call securing access and protecting economic interests. Let's take Britain as an example. One approach was to colonise. The other approach was to assert extraterritorial jurisdiction or through treaties of capitulation. The joint stock company was central to both modes. As the historian Phil Stern has described, the model had been developed for overseas ventures, but as I think he's a trusts lawyer at Cambridge or Oxford, I think Oxford, Andrew Televantos tells us, the model came home to Britain in the 19th century. And by the middle of the 19th century, it had become relatively common for businesses in Britain to be conducted by incorporated entities. Statutes of general incorporation were passed and more corporations sought to do business abroad. The legal situation inside the particular colonies was governed by what we might call intra-imperial law. And as the 19th century drew to a close, the ambition of many jurists was that British company law should be harmonised across the territories and the colonies and the so-called self-governing territories, and that they should all pass implementing legislation modelled on British law. The context of this, of course, was related to the expansion of capitalism, inter-imperial rivalries were intensifying, new industrial powers were emerging, capital markets were being developed. The result was a jurisdictional patchwork, but its combined effect was to protect corporate interests. So it did vary from place to place, but many colonies adopted the central element of the Companies Act 1862. By 1908, the United Kingdom had consolidated its company law into one statute, and mirroring acts were passed in many of the colonies. And the Indian Companies Act of 1913 is a good example. In the non-Western world outside formal colonies, so that was the story inside the colonies, outside the colonies, European states sought to protect their interests through assertions of extraterritorial jurisdiction. What that meant was European states asserted an ability to make and apply their own laws to matters affecting European subjects and interests, including corporations and commercial interests, and developed a repertoire of techniques to do so. This is an image from 1872 of the Iwakura mission sent to the US, partly to try to negotiate the end of extraterritorial jurisdiction. Needless to say, it was not welcome where it was being implemented. Anyway, through various means, including war and threats of violence, Britain, for example, imposed extraterritorial jurisdiction on Japan. I'm using today's names, China, the Ottoman Empire, and other polities. And they did this through the infamous unequal treaties or capitulation agreements. At home, they passed the Foreign Jurisdictions Act, which governed the exercise of extraterritorial jurisdiction as a question of domestic law. The technique that is embodied in this combination of a domestic rule with an extraterritorial effect was a precursor to many of the doctrines and rules that were later to be asserted as private international law. And a good example of this is if you look at the examinations for consular officials run by the British Foreign Office, generally those exams did not include any international law, except that by 1917, the examination for consular assistance in China and Siam included the topic of private international law, showing how this replaced the idea of extraterritorial jurisdiction. So the effect of the combination of national laws and treaties was to allow corporations incorporated in Britain to assert rights abroad and to call on British laws and forms of adjudication to enforce them. Extraterritorial jurisdiction asserted by one European state allowed other European states to access the courts of the European state that did it first in, for example, the Ottoman Empire. This form of legal standing coalesced with the treaties that I mentioned, which extended the recognition of companies to each other's imperial possessions. And the net result was that European and American corporations could assert their personality abroad as well. And those asserted rights, which were highly contested, were held in place by this jurisdictional patchwork or net, if you like. After the First World War, these threads being spun earlier began to be woven together institutionally. This was also the moment when the debate on international minimum standards began, a need for international arbitration began to be asserted in the belief that these techniques would protect what was suddenly being asserted by liberal jurists as private rights by foreign governments. And remember that there's pre-revolutionary rumblings happening at this time as well. So let's confine ourselves, though, to the travelling corporation, because in the 1920s, the specific question that we're talking about was taken up at the League of Nations, and a subcommittee recommended to the Committee of Experts for the Progressive Codification of International Law that the question of the recognition of the legal personality of foreign commercial corporations be regulated by international law, ideally through a multilateral treaty. The Committee of Experts declined to resolve the issue, but noted that it was to be taken up by the Hague Conference on Private International Law. And I'm going to come back to that organisation, so don't forget about it yet. But in 1926, the League also created the International Institute for the Unification of Private Law, or UNIDROIT, and this was done at the urging of a few powerful states. It was taking place against the backdrop of the nationalizations happening in the Russian Revolution and the Mexican Revolution, and it was presented even against that backdrop as a technical exercise to advance the project of unifying private law. In substance, this exercise of unification was protecting, intentionally or not, the interests of foreign corporations and European companies operating in the non-West. Okay, to sum up where we are now, by the early 20th century, as far as the Western states were concerned, incorporation had gone from a conferral of status in one state, recognised by others as a question of comity, which hinged on a benefit to the state, extending that recognition through a discretionary exercise of power and secured reciprocally through treaties, right? Benefit, discretion, reciprocity. It had gone from that to generating a blanket rule, a legal personality, which Western states were asserting should be recognised by other states as a principle of private international law. So from a question of comity to a blanket rule. The effect of this was to crystallise corporate legal personality itself and to make it portable. From roughly that time onwards, the travelling corporation would appear in public international law only in relation to procedural questions about proper nationality, not substantive questions about comity or legal personhood in an international setting. And you can do a fact check on my argument by looking at the early cases of the Permanent Court of International Justice. For the non-Western world then, the corporate personality of Western corporations was a foreign idea which was travelling with extraterritorial assertions of foreign law. These assertions were an aspect of a wider contest over authority, over economic relations, I believe we call it imperialism, and broader relations of encounter between both political communities and rival laws. And in all cases, the threat of violence lurked in the background. Okay, so as the story moves closer to the present day, the question is, what happened to the recognition of foreign corporations as states in Africa and Asia decolonised in the middle of the 20th century? What did decolonisation mean for the scope of legal authority in the former colonies and in the non-European world more generally? As an aspect of their hard-won independence, was it open to them, as it had been to the Western states, to decide whether to accord legal personhood to corporations incorporated elsewhere? Well, foreign corporations were a centrepiece of struggles to assert economic independence. But debates around foreign corporations did not take the form of substantive questions around whether a state should recognise the legal personality of a corporation incorporated elsewhere, or even whether it should recognise it with conditions. Remember, as between states in the West, Recognition of corporate personality was effected through principles of comity, discretionary principle, beneficial, whether it was beneficial was the test, and that was this ability was an important feature of a state's authority to decide what was best for it in economic terms. But during the anti-colonial struggle, debates around foreign corporations did not appear as prior and fundamental questions around authority and the recognition of legal personality. And when I first realised that, I was extremely puzzled as to why not. And what I realised was it was because of the invention of private international law and its institutionalization that the appearance of arguments about corporate personality were treated as procedural questions about diplomatic protection, in which only the question of proper nationality was at issue, not the question of the legal status of the corporation per se. And Barcelona Traction's a really good example of that, because no matter how hard you look, some of you won't know this case, but every international lawyer in the room will be nodding their head, because no matter how hard you look, the question of personality per se is not a question in the case. It's only a question, it's only treated as questions of which nationality should apply. So this pattern was this patterning was part of a wider context of anti-colonial struggles that were beginning to bear fruit. The new international economic order, for instance. But the more widespread and effective those struggles became, the more Western states and corporations tried to maintain the jurisdictional arrangements which had facilitated corporate mobility and more generally protected corporate interests. Those actors continued those efforts during and after decolonisation, inventing, reinventing and repurposing doctrines of international law like diplomatic protection, like the doctrine of acquired rights, like state responsibility, and many more to maintain the patterns of economic relation that had been established during the imperial period and to call them international law. On one level, we could describe this in terms of the consolidation and spread of capitalism, but that's too easy, because if we want to attend closely to the law story or to the how story, as I'm fond of saying to my students, we need to understand the practices by which legal authority was being distributed between states in the global north and states in the global south. That is a historical story, but it's not a progress story and it's not an inevitability. It's the patterning of a particular relationship and its stabilisation through normalisation. This is where both legal education and the disciplinary routines of international law fit in. So legal education is part of that story because as law teachers or as practitioners or even as scholars, we do not stand outside history, neither now nor in the past. Part of the history of the company-state relation is the history of our discipline, of our jurisprudence, and of our teaching, and how we transmit practice and technique and understanding. This is particularly true when we are considering the distribution of authority in times of colonisation, a moment of great importance in the history of crafting forms of relation between corporations and states. You'll be happy to know that law teachers and legal scholars are world makers rather than technicians, because law's authority is not something fixed and transcendent to be possessed, but something which has constantly to be performed. Authority is not a thing, it is a practice. And legal education is a key element of the ongoing practice of authorization. This happens through the practices and techniques which classify, define, distribute, and authorize things in particular ways. So one example of a technique of authorization is definition. So when we stand up in front of a law class and we say, what's the definition of law? And we say law is defined as state law, we are not teaching a fact. We are performing the authorization of one law over another. The effect of this is particularly visible in places like the one I come from, Australia, where there is a contestation between forms of law. It's an unsettled settler colony. It's also visible in Canada, the United States, and many states in the global south that we can think of. Another technique of authorization that we use when we teach or write jurisprudence is classification. And for the purposes of shaping relationships between corporations and states, the way we classify things as public or private and national and international and distribute arguments and doctrines between them is particularly important, in large measure because corporations are very good at playing across the lines of public and private, but that's beside the point for the present purposes. So let me explain. In the present, today, this is taken from my own law school's website, there's an institutionalized division in the law school between public law subjects and private law subjects. That's the case in my law school. It may be the case here. And generally, public law subjects are thought to be those which involve relationships between the people and the government. And private law subjects are about the relationship between people and other people. One important effect of this division is to naturalize the categories of public and private. This naturalization or shorthanding backgrounds the role of the state in creating and guaranteeing the legal forms that shape relations between people in the so-called private realm. And these private or background forms of relation include property, contract, labour, money, legal personhood, including corporate personhood. In familiar approaches to teaching international law, we teach students that international law is divided into two categories, public and private. They've even got different doorways at the Hague Academy. In familiar approaches to teaching international law, under the heading of public international law, we place relationships between states, and we include topics, or individuals and states as well. We include topics like human rights, environmental treaties, and war. Under the heading private international law, we place cross-border issues involving what we typically think of as private actors, such as corporations and individuals, in areas like conflicts of law, commercial arbitration, marriage, divorce, contract law, investment dispute, etc. When the idea of private law meets private international law, the private realm becomes a matter of national or domestic jurisdiction, and the international element is rendered procedural. There's no more substance there. The substantive questions are matters for national law, and the international question is about which national law applies. This educational and disciplinary patterning is a product of the 19th century. Specifically, now there's always a danger putting up a slide with dates because you're going to be distracted. But I just wanted to give you a quick sketch of the concentration of events in a certain moment, because specifically the pattern is related to the rise of the nation state, imperialism, colonialism, and the establishment of university-based law schools in the common law world, including in many of the colonies. In the Anglosphere, at least, the professional law school and state authority over legal education are both a product of the late 19th century. Jurisprudence is also crucial here, and the most potent or influential strand of jurisprudence being taught at these law schools at this time was legal positivism. Positivist theories have many aspects, but perhaps the most fundamental aspect of the positivist assertion is that state law is the only proper law. The distinction is often taught today with an emphasis on theory and the idea of a difference between positive law and natural law. But for those of us with an interest in history, particularly histories of empire, we can notice that this is a jurisprudence suited to the consolidation of the state form, the imperial ambitions of Britain, and the juristic activities of the settler colony. It's no coincidence that you establish Victoria, you open the Melbourne Law School shortly after. This is because at around the same time that legal education was being formalised in universities, there was a violent global jurisdictional contest between state law and other forms of law. That includes that struggle in the colonies, but also the formation of European nation states, contests between company and crown in India, contests between European empires, the Ottomans, the Qing dynasty, the Tokugawa shogunate, each asserting different laws. Against some entities, state law was asserted to negate their claims, like Indigenous people. Against other entities, state law was asserted to relativise or subordinate their claims, like conquered entities. In other places, state law was used as a lever to prise open the door to transformation through so-called modernisation projects. So like in the Ottoman Empire, for example. So the modernisation, the transformation claim. But for others, none of those three that I've mentioned, but for others, like companies, I would argue, hopefully controversially, that state law was being asserted as a way of brokering a deal through offering a means of protection for the so-called rights being asserted abroad in return for those entities supporting the state's own claims both at home and abroad, so to speak. And so just as the classification of law school subjects as public or private causes us to forget that state law guarantees private law or private rights, and I know you're much more familiar with that idea, it also encourages us to forget the role that those so-called private relations play in turn in authorising, performing and stabilising state authority. This is law itself as a kind of public-private partnership. So this co-constitution and backgrounding, I haven't got time to talk about this now. Maybe we'll come back to it. You know, this is Elon Musk's venture. This co-constitution and backgrounding is particularly relevant whenever there's a contest between rival laws and state laws. And as both a subject of instruction and a field of scholarship, jurisprudence is implicated in this co-production. The relationship between jurisprudence and institutions is circular, not unidirectional. And even if we don't mention it at all when we're teaching, we are always teaching a jurisprudence and a juris theory. We're performing the authority of a particular law. So, for example, we could describe someone like John Austin, who wrote his famous Province of Jurisprudence determined in 1832, as writing not sociology, nor even a normative theory, but as writing prefigurative theory. Prefigurative theory means a theory which presents itself as a description, but which is actually describing what it would wish to see come into being. So when Austin was writing, and when he famously described law as the command of the sovereign, he said this against the backdrop of a great plurality of laws. So he was not asserting a fact. I mean, he was not stating a fact, he was making a claim. But because of the genre in which Austin wrote, the prefigurative genre, and others like him, when we look back from the present, we imagine, and indeed are guilty, including myself, of teaching as though he was describing a fact rather than making a claim. So historically speaking, in the 19th century, law schools are emerging against a backdrop of legal plurality. State law was being prefigured definitionally as the only proper form of law and authorised as such through the kind of jurisprudence being written and taught. At the same time, a classificatory exercise was part of that authoring and authorisation, such that proper state authority was being circumscribed along ideological lines, so that arguments around both personal and market relations were being, or economic relations were being distributed to the private realm, the private spheres of the family and the market. It's worth asking again what the effect of all this was in the colonies, because the authorisation of state law was, of course, crucial to the colonial project. But the public of public law in a colony is very different to the metropole, because the public to whom that law was addressed in India, say, was not the indigenous population, but the British public. This meant that in the colonies, public law had no local public meaning in the colloquial senses of democracy, legitimacy, benefit. And private law was often the locus and source of the authority to govern. But the objects of government then were putatively improvement and actually profit, or in a more familiar vernacular, civilization and commerce. So that's a sketch of the relationship between the formalisation of legal education, the authorisation of state law, and the co-production of private rights and state authority. You have 45 minutes to write a short essay. No, you don't. But so last piece of the puzzle is, how does teaching international law fit into this story? Or how does the way we transmit international law fit into this story about the naturalisation of the travelling corporate person or the travelling company? Another historical story, this time with our friend Jeremy Bentham. Because remember, it was the utilitarian jurist Jeremy Bentham who christened international law in 1789. And most people writing from today write as though he was just rechristening the law of nations or giving a new name to an old idea. But in my argument, with this christening comes a redescription, and again a prefiguration, and again classification. The prefiguration was again about the primacy of state authority, but remember we're working in a slightly different register now. But the classification was about what arguments, activities and relationships belong to the domain of the international and which do not. Let's start with the question of the state again. The law of nations, the precursor to international law, was plural, with lots of different actors, including companies, churches, non-Christians, non-states, other empires. And this plurality included a variety of coexisting laws of encounter, or interpolity laws, as the historian Lauren Benton calls them, the Tokugawa laws, the Qing laws, indigenous laws, lex mercatoria. These laws had different types of legal subject. But in Bentham's international law, the only proper subject is the state. The different laws of encounter also had different ways of talking about authority than sovereignty. Not so in Bentham's international law. Only sovereignty equals authority. Bentham's terminology did not instantly become the brand, but he was putting forward a view that was closely aligned with Britain's interests. So in this context of plurality that I'm trying to paint a picture of in 1.5 seconds, both formal imperialism and quasi-imperialism are what we could call jurisdictional claims. They make a claim to authority, and they make a claim to authority that purports to assert the meaning of law proper. They are extra versions of state authority, and they are a claim that a particular type of law was law in general. And European international law provides both the language and the technique for making that claim stick, or making that extra version into an extension. And the concept of sovereignty is key here, because people use the term sovereignty as though it is an abstract term, which means legal or political authority per se. But it is not. It is a particular term. It has a particular history. It comes from a particular place. It's not a universal term. The late Peter Fitzpatrick, who was himself an academic here at Queen's University, frequently observed that sovereignty is the pivot in the spread of modern law. So Austin tells us that law is the command of the sovereign, but if we flip the axiom, we see the underbelly of a legal theology in which sovereign is properly only he who issues a certain type of command. So we know from many people, Uday Singh Mehta, Edward Said, Ngugi wa Thiong'o, Frantz Fanon, that there are lots of general practices of knowledge making, narrative, myth, etc., about civilization, modernization, which discursively are underpinning those legal technical assertions. But when Bentham defined the term, he implicitly excluded from the definition of law not only the non-state laws of non-European polities, but also the non-state laws from other kinds of groups, including merchants. So Bentham excluded lex mercatoria, the law merchant, which was a big part of the law of nations, from public international law. So that's quite different to what was practiced under the law of nations. And what Bentham prefigured as international law encompassed only that which we now consider public international law. So in a way, both Indigenous people and corporations were suffering from the same thing through their exclusion from the capacity to make law, but with very different effects, right? International law was an important carrier of the distinction. But remember, we jurists are world makers, not technicians, and world making involves practices of authorization, including legal education as a practice of transmission. So our question now becomes, how was international law being transmitted around this time? Compared with the law school in general, international law does not become a subject in the modern law school until quite a bit later. This is a picture of the LSE in 1917, because even by the end of the First World War, there were only 2 chairs of international law in England and none in London. A few lectures were being given at the LSE, but apparently only 4 people attended. Instead, that's true. Well, that's according to this guy called Edward Whittick. But instead, the most significant sites of disciplinary formation in the history of European international law were the international law societies and associations. So we know from the work of Martti Koskiniemi that in the late 19th century, European international law was being professionalised and the associations of international law were being formed. And in this disciplinary transformation, in the absence of a legislator, the scholar played a particularly important role, or the publicist, I should say, actually. So think of the importance of the writings of eminent publicists, from friend of the Jessup Mutter, to the modern doctrine of sources. This is important because if this is a key vector of transmission now, not modern law schools, but these associations of international law are forming at the heart of the disciplinary and professional project, but they're composed of people who are also advising and arbitrating. And in 1893, these men convene at The Hague the first conference on private international law. This is a conference which becomes a permanent institution. It's directed towards substantive questions of conflicts of law, but the men of 1893 take up the name that the American Joseph Story had coined for the field in 1834, private international law. But at the same time, they are redefining the field. Because with the asserted universality of state law, there is no place for conflicts between rival types of law or overlapping jurisdictional practices. And so the men of 1893 agree that private international law should be understood as positive law derived from state law, which is binding upon all states. So, in a sense, these men of 1893 were performing what Bentham had prefigured in 1789. Namely, the state is the only proper international actor, And other than the substantive rules consensually agreed by states, there are only procedural questions about plurality in the shape of which states' laws apply. So in contrast with the law of nations and the idea that conflicts was a substantive question of plural law, in the account of the men of 1893, conflicts of law should now be understood as a procedural question involving a conflict between rival laws of nation states. So retrospectively, people almost always describe this development too as simply giving a new name to an old idea. And today, we seem to use the terms private international law and conflicts of laws interchangeably. But in my argument, the christening of private international law marked a shift rather than just a renaming. And when people use the language of conflicts today interchangeably with private international law, it's the meaning of the older term that has changed. It has shifted to be synonymous with private international law rather than the other way around. So the name didn't change, but what it went from was a conflict of laws to conflicts of law. Don't worry, I'm nearly finished. But why does this matter? It matters because one version stages a lawful encounter between rival laws, and one version displaces rival laws in the name of a particular law being asserted as universal. This shift displaces the ability to decide, the key marker of so-called sovereignty, displaces the ability to decide on what legal relationships and legal forms that someone can recognise, and it does this by stabilising or backgrounding or naturalising certain forms of relationships. Those were forms crafted in the context of coercion and violence. So just at the same time as the non-European world was decolonising, the Western world was engaging in practices which would circumscribe its authority as much as possible. And whether this was its primary purpose or not, it had the effect of protecting corporate interests and upholding the ability of the corporation to travel without condition through the decolonisation period of the mid-20th century. And as international lawyers, we continue to practice the techniques which distribute authority in this way. But we often do it now in the name of development and harmonisation. Okay, it's time to conclude. Draw the threads together. In this lecture, I've tried to show that the growing imbalance between corporations and states is in fact an instance of empire coming home. Techniques that were forged in the imperial moment to facilitate the exploitation of far-off lands in the name of profit, for profit in the name of civilization, are being deployed globally and in the global north, this time under labels like inevitability, necessity, progress, there is no alternative, all the while increasing inequality and the authority of large corporations. I don't have time, you'll be happy to hear to recap the methodology, but we can talk about that later. But if we want to reshape the relationship between companies and states, the first step is, as Lord MacDermott exhorted us 50 years ago, to scrutinise familiar terms. And that means making strange the familiar, denaturalising what has become normal, and in my view, doing this in part through a history both of legal forms and of transmission of technique that we do through our legal teaching every day. Legal knowledge makers are active participants in authorising those forms. Because if we teach international law and ignore histories of the company-state relation and the role that legal education has played in that relation, we won't answer our responsibilities to our students very well. Instead, we will offer them an account that is politically and ethically incomplete, but also analytically unhelpful in our attempts to increase our common good in the present day. That's the end.